Hello friends, Namaskar. Myself is Dr. Soni. I am an advocate and a defense counsel. In today's class, I will discuss about a defamation case. I will discuss about the defense mechanism in consequence of which we could easily encounter a false case of defamation. So basically, we have to note down certain conceptual perspective so that we could easily understand about defamation. And I will specify you the process means the defense mechanism so that we could easily encounter the allegation. So I will specify you the practical way and technical way. First of all, we have to understand that the defamation is inter alia defined in section 356 of BNS. The provision says defamation means if accused by words either spoken or in writing or by signs or by the visible representation makes or publish in any manner any imputation concerning any person in consequence of which he is having the ill intent to harm or knowingly or has reason to believe that such imputation will harm the reputation of such person. In that scenario, the offense of defamation is said to be committed. So by the bare perusal of definition, it is quite clear to us that mens rea is one of the essential requirement of offense of defamation if the consent imputations are true. In addition to this, the concerned person making the allegation is having no intent to harm the reputation of the concerned person. In that scenario, the offense will not be made out. So basically, the prosecution is supposed and the prosecution is required to prove the offense beyond reasonable doubt. I want to clarify that there is no presumption against you. The prosecution is required to prove the facts. The prosecution is required to prove the violation. The prosecution is required to prove each and everything beyond the reasonable doubt. If prosecution fails to do so in that scenario, we could have the benefit. So the legal aspect is clear to us. Now I am coming on the practical aspect along with the technical aspect. Sometime there might be a possibility that the concerned complainant in counterblast had submitted a false case of defamation. So basically, we have to identify whether the said scenario occurs in our case or not. If it occurs, then we could have the benefit. But regarding this, we are supposed to put up the documentary evidences so that we could clarify our stand. In addition to this, I want to clarify that the FIR is not permissible in case of defamation. Means the police could not register the FIR. Even there could not be any charge sheet as per section 193 of BNSS. The true or the perfect course as per law is that the concerned complainant has to file a complaint before the concerned court. Once the complaint is filed, in that scenario, the magistrate is bound to follow the process of section 223 of BNSS. Basically, it is part and parcel of chapter number 16 of BNSS. Inter alia, it provides the process to take cognizance on the complaint. It simply says, whenever a complaint is filed before the concerned court to take the cognizance, in that scenario, the magistrate will ensure that he is having the jurisdiction to take the cognizance of the offense, and after that, the magistrate shall is imperative, examine upon oath, not on affidavit, the complainant and the other witnesses, and after that, the consent substance shall be reduced in writing, and subsequently, it is required to be signed by the complainant and by the witnesses and also by the magistrate. In addition to this, the cognizance could not be taken by the magistrate without according the opportunity of being heard to the concerned accused. So, if there is non-compliance of section 2 to 3 of BNSS, we could have the benefit. Regarding this, the recent judgment of Honorable Karnataka High Court, which is dated 23rd of Jan 2026, is quite important. In addition to this, we have to note down two important judgments of Honorable Supreme Court. Judgment number 1, 1993 SCC, page number 149. It says the judicial process must not be an instrument of harassment. Judgment number 2, 1998 SCC, page number 749. Summoning the accused in the criminal case is a serious matter. The criminal law cannot be set into motion in the routine manner. So basically, if there is non-compliance and there is no reasoning in the order, we could be succeeded. In that case, even the proceedings had been quashed. So basically, we have to ascertain whether the allegations are specific or not. In that scenario, we could have a very good defense on the record, because if the allegations are general, the allegations are omnibus, there is non-specification, allegations are inconsistent, and apart from that, there is lack of corroboration, then we are having a very good case on board. In addition to this, if the evidences are not produced And even though the evidences are electronic in nature, in that scenario, Section 63 of BSA is quite important. So, if the allegations are non-specific, and apart from that, your role is not specified, in that scenario, you could be succeeded. So, basically, regarding all the scenarios, we are having three important judgment. Number one, judgment pronounced by Honorable Guwahati High Court, which is dated 4th of Feb 2026. Number two, judgment pronounced by Honorable Jammu Kashmir High Court, which is dated 7th of Feb 2026. And last one is judgment pronounced by Honorable Karnataka High Court, that is 23rd of Jan 2026. So, whenever you are in trouble and inter alia facing a false defamation case, you could easily submit your case in light of guidelines which are propounded by Honorable High Court in the judgment which I specified to you. See you in the next video. Till then, Jai Hind, Jai Bharat.